Thank you so much. The guest is gonna arrive in 2 minutes. So thank you for coming. Good evening, everyone, and thank you for coming for this event. My name is Ishita Jain, and I am the head of the Logistics Committee of the Trial Advocacy Society. I would like to welcome the President of the Trial Advocacy Society, Mr. Piyush Vyas.
First of all, thank you everyone for showing up on a weekday, and I'm pretty sure there are ones who have missed their classes in order to attend this particular event. First of all, it is my profound privilege as well as honor to welcome Advocate Shri Singh for our two-day event, which the Trial Advocacy Society is organizing on examination in chief and cross-examining. I think it would be an understatement to say that cross-examination forms the heart and soul of a trial. However, I feel that it is again imperative to mention that cross-examination, this art and skill, cannot work in isolation. It operates in a context, and whenever we are to grasp this, it has to be operated and has to be learned in a context of a trial as a whole. Since I mentioned that cross-examination is an art as well as a skill, so it becomes very important to understand that it can be learned. And today we have none other than the master of courtcraft, Advocate Shri Singh. I request all of you to have a round applause of a hand for sir. Sir is a brilliant criminal advocate who practices in Delhi and is having a roaring practice there. Few of his leading cases, definitely the list is non-exhaustive, but they include 2G scam case. They also include Delhi excise liquor case, and the list goes on and on. Apart from sir being a brilliant criminal advocate, I just happened to interact with his intern, and he happened to tell me that sir is a great person in and out. He also informed me that sir used to interact with his interns, used to have one-on-one conversations, who did not just used to talk about the law, but also about the marks and the burden that the students are facing. With this, I would invite Professor Aparna Babu George, who is our faculty coordinator, to felicitate the guest. Not taking much time of yours, I would now like to invite Sir Shri Singh to address the gathering.
I'm sorry. And the pointer. आगे कहाँ पॉइंट कहाँ करना है? Fair enough. All right. Well, thank you very much for that introduction. It was not fully deserved. I must correct the record. In no way, shape, or form am I, or do I claim to be the master of the courtroom. In fact, there's a slide in this presentation dedicated to who exactly is the master of the courtroom, and we'll come to that. Thank you once again for inviting me to your lovely campus. This is the first time I've come to your campus, and it's a far cry from the campuses that we're used to seeing, and I'm sure that all of you are having a wonderful time here. Well, I have been asked to share some thoughts on examination in chief, and in no uncertain terms I've been told not to get into cross-examination, which is actually far more interesting. So I will play within the rules and stay in the pecking order, and let's have a quick discussion on examination in chief. By a quick show of hands, how many of us here have read CRPC courses, roughly? All right, that's not bad. Right. So the stage at which examination in chief becomes relevant in a case, as most of you are aware, is once the trial commences. Prior to the trial, there is a process of inquiry, and prior to the process of inquiry, there's a process of investigation. So if I reverse that, and of course, this presentation is supposed to be agnostic as to whether we are dealing with civil law or criminal law, because examination in chief is used in both. It's part of the Evidence Act. It is also something that is used in several arbitrations. So insofar as the general principles of examination in chief are concerned, they are roughly, in our Indian context, governed by the Evidence Act. So but if you were to take the example of a criminal trial, something I'm a little more familiar with, at the end of the investigation stage, that's pretty much the situation that the investigation and the investigative units, the prosecutorial units, are in. And for those who can't read the caption, it says there's so much evidence we should put some aside for a different case, right? And the job of examination in chief is to make sense of this room and to present this room, this mess, in a manner in which relevant facts are placed in order and are placed in service of facts in issue, right? So, by show of hands, how many of us have read evidence recently? Considerably fewer. All right. Does anyone have this with them? Well, you have computers now, right? So I'm sure you'll access them. So once the trial has reached its stage where the first witness is to be examined, the examination in chief will in almost all cases kick off that particular phase. Section 137 of the Evidence Act will govern what exactly is examination in chief, and is defined very simply as the examination of a witness by the party who calls such a witness, right? So in a criminal trial, all the witnesses are called for by the prosecution. So it is fairly obvious that the prosecution leads examination in chief, and the defense then cross-examines. In some cases, the prosecution will then have the chance of re-examining the witness. In a civil case, if there's a suit, then the plaintiff would lead examination in chief and the defendant would cross-examine. The process by which evidence is placed on the judicial record is examination in chief and cross-examination. So let's again take the example of a criminal trial. all the evidence that is collected during the course of an investigation is placed before the concerned magistrate in our context, a jurisdictional court, and the jurisdictional court will be invited to take cognizance of offences and to issue summons against the accused. Once that process is done, the accused will appear. If the accused is already on bail, they will continue to remain on bail, else proceedings with respect to bail will continue. And copies of whatever documents have been collected by the investigation which form part of the charge sheet will be placed on record, and a copy will be given to the accused. Once the accused receives a copy of the record, the accused will then be invited to advance arguments on charge. Once charge is framed, the trial begins, or rather if charge is framed. So the last point on this slide, the mode through which a party asserting a case places facts on the judicial record. So the material that is collected during the course of an investigation, the material that is collected or placed or put into service by a plaintiff, all that material is simply material and does not become evidence unless it goes through the eyes of all the witnesses that they are citing. So there are some fairly self-evident processes that we all follow. A witness will come, will take oath in court, and once the witness takes oath, the witness is expected to answer questions, is being led through an examination in chief. We'll just go through exactly what that process entails. But after that, whatever the witness says, as long as the same is relevant, that will be taken on record, and that record, including oral statements that the witness is making and documents that she is relying on, all that record together forms evidence, and that evidence is then considered as part of the judicial record, subject of course to cross-examination. Now, the Evidence Act is a fairly simple document to read through. So there's a chapter on witnesses. The first provision of that says who is competent to testify, who can actually be a witness, right? So you should be of sound mind, you should be an adult. In some cases, child witnesses are also allowed to testify. Their evidence is scrutinized differently by a court. But by and large, you should not be incompetent, mentally incompetent. So it is possible for a child to testify. It is also possible for an adult who is mentally incompetent to be declared to be such and not be allowed to testify. In several, and a large number of you, I'm sure, will enter the profession as counsels or agents in arbitrations, you'll find that the entire process of examination in chief is in fact reduced to something that you may have heard of as affidavits by way of evidence. So instead of taking a witness in real time through their own case, at times an evidence by way of affidavit is filed, and that is also an affidavit, so that is also sworn testimony. And once that is put on the court, the questions relating to further examination in chief are normally sidestepped. The process is made a lot faster. This is a mode that is eschewed or that is not used in criminal trials, barring a very, very small and stated number of cases where certain types of witnesses can in fact give affidavits by way of evidence. Those are normally of a formal character, experts of certain types, if there's only something that is documentary in nature that has been brought on record. Otherwise, the special character of criminal trials is such that examination in chief will almost always be done in person. Yeah. So it's fairly evident, and I'm sure all of you are aware, the examination in chief as the process is followed by cross-examination by the other counsel appearing for the accused in the cases of criminal matters, counsels for the defendants in matters such in civil matters or in arbitration matters. If, and it's a big if you as the counsel for the prosecution or as counsel for the plaintiff find that there are some elements of your examination in chief that have in fact been dislodged by the cross-examination done by your opponent, you are, with respect to certain situations, and we'll go through those, allowed to re-examine your witness, right? But the scope for re-examination, you have to remember, is very limited, and it is almost always heavily supervised by the court. So the court will normally allow you to re-examine on just a few issues, if at all. In several cases, the court may in fact may not permit you to re-examine, right? So now, how do you prepare for an examination in chief, right? The process by which I would commence an examination in chief would differ widely with that of another lawyer, or differ widely with respect to other prosecutors. Everyone is going to have their own particular way in which they want to proceed. Over my few years at court, online searches are hugely helpful, by the way. But apart from those, the first thing that you would want to do is set up what I would term, and several others would term, as a case theory. What is it that you want done in the case? And I would like you to imagine, if I were to reverse this process, if I was to look at a case against a client of mine as a defense counsel, I have to be ready from day one with whatever is my defense with respect to as many parts of the case as I can understand today. Which is why you'll find, if you're reviewing criminal law on criminal procedure developments over the last few years closely, you'll find that there is a trend where in more and more complicated matters, lawyers, especially on the defense, are beseeching the court that please crystallize the case against me before we move to trial. Don't allow investigation to go on endlessly. Close their investigation, crystallize the case so that I can cross-examine. The reason is this: both sides, you can, as an analogy, in a criminal trial, both sides are trying to place a picture before the court. Right? The prosecution has endless time, virtually, from the date on which they record the offense and they conduct their investigation. The charge sheet that is filed by them, which is their final report, that represents their best possible case. That's the best case they can come up with, completely uncontested, right? Nobody is asking them any questions. That is their case. That's the absolute height, apex of their case. That's the picture that they are convincing a court that this is the picture that we will end up with after this trial, right? But this picture is not fully resolved, right? So I would ask you to take a look at that picture, take a look at it closely, and you'll find that it's actually a jigsaw puzzle. It's not a picture. It has little pieces, and each piece represents either a piece of evidence or a witness. And each piece has to be individually developed by the prosecution. Each piece will have to be brought on board through the process of examination in chief. The prosecution or the plaintiff, as the case may be, is dominus litis, right? That's a fancy way of saying that they are the master of their case. They will determine the order in which witnesses will be brought. So, and that order may be determined on the basis of a variety of factors. In cases with respect to sexual assault, by the time the first witness is ready to be examined, in a majority of the cases, the accused, if arrested, will be in custody and will be fighting for bail. So the courts will probably say that as a condition to release you, I would want the prosecutrix or the victim to be examined first. So in that case, PW1, prosecution witness, public witness, depending on who you speak to, PW1 will be the victim. PW2 will be a guardian or a parent, depending on the kind of case. In other cases, PW1 in a corruption case may be a sanctioning authority, right? In several other cases, in a murder case, PW1 might be the eyewitness, might not be the eyewitness. The prosecution may feel that given the fact that bail considerations are going on, there is a threat to the prosecution witnesses, maybe we'll begin with some witnesses who are not that relevant, right? And keep the eyewitnesses in our back pocket for the moment. So these are all prosecutorial decisions. These are all decisions that are being taken by the prosecution, by counsel for the prosecution in their capacity as dominus litis. And very rarely will you find that a court, and even rarer still, the opposite side, has any say in which the order in which these particular witnesses are going to be brought. And for that purpose, because of that, from day one, if I'm a defense lawyer, I don't know which part of this puzzle is going to be placed before me first, right? So I have two jobs to fill as the opposite lawyer, whether I'm a defense lawyer or I am the defendant's lawyer. I can play a spoiling game. I can prevent my friend on the other side, the prosecution, the plaintiff, from being able to collect the pieces that he needs, right? So each time he puts up a puzzle piece, I say, well, that person is incompetent to testify. Each time he comes up with a sanctioning authority, I can say, oh, well, questions of sanction are irrelevant in this case, right? So that piece goes out of the picture. He brings an eyewitness, and I say, well, you know, this is a stock witness. This is a witness that you pulled out 42 times over the last 3 years. So I'm challenging this witness. Now, whether or not that prevents the witness to be called, that certainly puts a dent in their case, right? I'm challenging aspects of whatever that witness has to say, right? Whether it is on grounds of hearsay, on grounds of there's an email being brought, I'm saying, look, I'm sure you've heard of 65B of the Evidence Act, right? That there's no 65B certification. This is a signed document of the witness during the course of investigation. It's hit by 162. Someone is trying to produce a disclosure statement. This is a disclosure that is hit by 25 and 26 of the Evidence Act. There is no, in fact, recovery under Section 27. So I am at one level playing a spoiler. Whatever that guy is putting up, I am tearing down. But I also have a secondary role. And in a lot of the special offenses that we are now increasingly seeing, especially offenses like PMLA under investigations done by the SFIO, in NDPS matters, there is an express burden placed on the defense to actually make out a defense. So apart from destroying or defacing or damaging the case or the picture that the prosecution is putting up, I also have to put my own picture on the judicial record. And that has to start from day one, right? By my cross-examination. So either side has to come up with their own case theory. And the only way in which I can put forward my version of events is if I know what I want my version to look like at the end of it, right? So, and these are fairly abstract concepts, but they're fairly simple to understand with examples. If I'm accused of committing murder, I have to decide front on, well, did I actually commit the act? Or did my client commit the act? In which case, if he didn't commit the act, well, then there's a defense of alibi. I was not there. If I find that, yes, I did strike a blow, there must have been reasons for why I did that. It was grave and sudden provocation, right? I was exercising my right to private defense. So I have to have a reasonable sense of what my defense is and what my case theory is. And the reason I've digressed into what the defense needs to do is that's the exact thing that the prosecution needs to do. But the prosecution has been doing that from the day the FIR or the case has been instituted. And the plaintiff has been doing that from the day on which they recognize that this cause of action is something that we have to litigate. So they have been building their case theories, right? Now, your case theory is tethered to reality, because a case theory could be anything, right? My case theory could be that the man on the moon has come and murdered someone. It's a viable case theory. There's nothing wrong with it. Except Section 3 will say, of the Evidence Act, says that look, all case theories are valid, subject to the fact that they contain relevant facts, and facts are relevant in relation to facts in issue. Right? You all heard these terms. And I'll invite you, in fact, just to see a few definitions of terms in the Evidence Act. Right? So if you can draw up your Evidence Acts, those of you who can. If you can turn to Section 3, the interpretation clause, right? So it has defined the term fact, and fact, for the benefit of those who don't have the act, means and includes anything, state of things, or relation of things capable of being perceived by the senses. And secondly, any mental condition of which any person is conscious. Now, these are very, very important phrases that have been put together in a particular way. And as you examine more and more cases in the course of your studies, in the course of your practice, whether it is a civil practice, a criminal practice, whether it is practice in arbitration, or whether you're looking at events as a counsel looking into a trial. So you're doing a due diligence for one of the large firms, you come across a case, you now have to determine as counsel for on behalf of a company, what is the relevance of facts that have been established during the course of a trial where the company for whom you are performing a due diligence has been involved, right? So whether or not a fact is a fact, is in fact a fact, is explained to you by this particular definition. And the role of a witness is circumscribed by Clause 1. So Clause 1 says, anything, state of things, or relation of things, which is fairly obvious, capable of being perceived by the senses. That tethers it to reality, right? So this is a reference to our five senses, right? So if I can perceive it, I can say that yes, the day was hot or cold. I can say that I saw this person, I heard this person, I tasted it, it was off, right? That's basically Donohue versus Stevenson, which you all have studied, right? So those are facts. Whether or not I want to get into a metaphysical discussion on whether or not, there is one God, there are 10 gods, there are 15 gods, there's a man on the moon, court says, look, you can engage in those discussions, but outside of whether or not a thing is a fact. For the purposes of resolving disputes, the Evidence Act says, this is what I believe is a fact, right? So as long as we are circumscribed, or we have circumscribed ourselves and our acts by the Evidence Act, this is what we have to prove, or this is what we have to disprove. The next phrase that is defined is the phrase relevant. So one fact is said to be relevant to another when the one is connected with the other in any of the ways referred to in the provisions of this act relating to the relevancy of facts. So this act says, I will now also tell you in what way are you going to be able to connect two facts together. I will tell you what is a relevant fact. So relevant facts, relevancy of facts is determined by the Evidence Act and by no other way. We do not know of another way in a courtroom to declare whether something is a relevant fact or not. So whether the day was hot or cold may or may not be relevant to a case, right? So if it's a case of forgery of a document and it is found on a Monday in a bank, Whether that Monday was in the winter or in the summer has absolutely nothing to do with the fact that this document has been recovered from a bank. You can argue, the fact that it was hot or cold is something that I'm perceiving with my five senses. But the answer to that is, it's not relevant to this case. There are a million facts. But only those that are relevant will be taken on record or will be discussed. And the last is a fact in issue. The expression facts in issue means and includes any fact from which, either by itself or in connection with other facts, the existence, non-existence, nature or extent of any right, liability or disability asserted or denied in any suit or proceeding necessarily follows. So this now tethers relevant facts. So facts, relevant facts, and facts in issue. Facts in issue relate to the case at hand. What generates liability, right? What generates a disability? What generates a right? We are looking at only those facts that are tethered to this statement of fact or law, that is the subject matter of a case generating either rights, disabilities, or liabilities. You can take a look at what is evidence. Evidence means and includes all statements which the court permits or requires to be made before it by witnesses in relation to matters of fact under inquiry. Such statements are called oral evidence. All documents, including electronic records, produced for the inspection of the court, such documents are called documentary evidence, right? So evidence is divided neatly into two parts, oral evidence and documentary evidence. Oral evidence is with respect to witnesses, but please mark all statements which the court permits, right? So while the counsel conducting examination in chief is the dominus litis, not the counsel but the prosecution as a whole, the master of the court remains the court. Who determines what is relevant and what is not relevant? It's the court, right? And this definition is actuated or is effectualized by section 136 of the Evidence Act. We'll go through that, right? This will be an exciting hour. The next three terms are proved, disproved, and not proved. And this is where the nub of the issue with respect to examination in chief and cross-examination and re-examination lies. A fact can be, at the end of a trial, in three forms. A fact asserted. Either that fact is proved or that fact is disproved. Disproved is that it doesn't exist. It can also be neither proved nor disproved, and it can be not proved. So a fact can have three particular ways in which it exists at the end of a trial. And this is relevant from the point of view of what was the burden of proof on the party and what was the standard of proof on the party. So we are all roughly familiar that in a criminal trial, burden of proof lies on the prosecution. So that the collection of pieces that the prosecution has painstakingly put together during the course of an investigation, that collection of pieces has to be proved by the prosecution. And we also use another term, beyond reasonable doubt, right? Beyond reasonable doubt refers to the standard of proof. So these are two competing, at times competing, but these are two concepts that go hand in hand. And you'll find when you do a slightly more granular look at the stages of a trial, the burden of proof and standard of proof doesn't remain consistent or doesn't remain consistently on one party and of a certain level. And by way of example, if tomorrow a case comes up where it is found that a senior member of, say, the armed forces, is alleged to have been feeding defense secrets to a perceived enemy of our country. The burden of proving that case is certainly on the prosecution. But if he applies for bail on the first day, the burden on the prosecution is almost always to the extent of reading out their case. That's about it. That person will then have to show, has an extraordinary burden as an accused, to demonstrate that he or she should be granted the benefit of bail. In some cases, say it's a PMLA offense, and instead of an armed forces officer, this is a senior banking officer of a large bank. And there's a case with respect to money laundering. The burden is in fact reversed by the statute in some readings of the law, that it is that particular individual who will have to demonstrate that they have in fact not committed the offense, which is an extraordinary burden even to discharge even prior to the prosecution having completed their investigation. So before they have crystallized their case, if I want bail, I have to show there's a reasonable chance that I am not guilty. Right? It's almost an impossible burden. But the point is that the question of burden of proof and standard of proof will keep on changing depending on the type of matter you're doing. If you're doing a suit, the burden of proof, the standard of proof changes. If instead of a suit you're doing an adjudication, say an income tax matter, the standard of proof will change again. If you're doing an arbitration, the standard of proof changes again. So you have different standards. You have preponderance of probability, you have reasonable tests, and you have, of course, beyond reasonable doubt. These three terms, proved, disproved, and not proved, they govern the status of facts when you're looking at these particular forms in which facts end up in. So my exercise in examination in chief is to prove my facts. I want these facts to be proved, to be beyond reasonable doubt. My opponent is trying both things, to disprove some of the facts and to say that, well, some of the facts that Mr. Singh is bringing have in fact not been proved, and some have been disproved. And when you weigh up the various columns at the end of the trial, that is when the court will finally ultimately say that, look, the burden of proof was on the prosecution, these are the facts that have been proved, these are the facts that have been not proved, and in fact these are the facts that have been disproved, and will then hopefully give a result in our lifetimes. Right? So to conclude this particular slide, when you're preparing for your examination in chief, you need to have a pretty good idea about where exactly your particular case is headed. How does one witness roughly tie into another? And you have to therefore have your case themes lined up. Right? Now, I had done my master's in arbitration a few years ago. I was attending one of the various workshops in that. And there was in fact a workshop on examination in chief and cross-examination. And I found this sentence in my reading materials, which is, well-prepared counsel will prepare a persuasive theory and theme which should resonate with the presiding officer. And I thought that's pretty cute, right? It was a European professor who was giving this, 73-year-old man. I said, it's cute that they think that my theory at the beginning of an examination in chief is going to resonate with the presiding officer who ultimately decides my case. Right? I started off as a junior counsel in some matters in 2007. We are still at the stage of charge. right? So, I mean, you can take this for what it is. But what I derive from this is the importance of having a case theory. Because if you approach a witness, whether cross-examination or examination in chief, only from the point of view of what that particular witness has come to say, in the absence of any context, you will almost always either not derive the full benefit that you can from that witness, and worse, you will probably damage your case. Because you will ask questions that are in fact intruding on, say, the questions that you would probably like to ask another witness. As someone who is going to present a witness to the court, is going to ask questions, is going to elicit answers, you are also under an obligation to the side that you are representing to ensure that you are able to anticipate what questions are going to be asked by the other side, both on issues of admissibility and on issues of merit. By that I mean, if I am asking a witness to depose as to a letter, I know that this witness is going to come and say that yes, I have produced this letter, I have written this letter, the investigating agency asked me for this, I have presented it to them, this is a seizure memo that shows that I have in fact taken this, I have submitted this letter. If that letter is a photocopy, is a copy, there will be admissibility issues. It is in fact secondary evidence, it's not primary evidence. So I should anticipate that. So I must be able to explain to the court, even before the opposition perhaps, as to why is it that a witness is coming and exhibiting a document that is a copy. I cannot rely on the fact that perhaps the court will ignore it because I'm otherwise examining 500 documents tomorrow. This is just one copy. Maybe it will just, in a pattern it will just slip in. And I can't rely on the fact that perhaps the opposition will not look at it. Because ultimately, when the matter has to be examined, whether or not something is admissible on day one of a trial may not be relevant to the sum total of the matter at the final stage when the court is deciding, yes, well, this letter, the original copy was in fact lying at X place, you produced a copy is inadmissible, and perhaps an important component of your case theory goes out of the window. And the last is fairly self-evident, is whether you are in a civil trial or in a criminal trial, it's not the law that will win you the matter. In a trial, it is the fact or a collection of facts. And facts will see you through poor law. So if you have a situation where there is adverse law against you, if you have compelling facts, because we are a common law jurisdiction, right? So I'm sure all of you are also studying equity. And you're familiar with our constitutional courts having powers under Article 226 and Article 32, writ jurisdiction. The power of writ jurisdiction in common law countries, when compared to their counterparts in civil law countries, which some of you will be doing in your senior courses in comparative law, is such that civil law countries will find their hands tied in order to cure adverse facts in the face of adverse law. By that I mean, so I'll give you an example. We were before a court recently in a matter where a bank had complained that a large amount of money had been defalcated by a set of 3 individuals, a husband, a wife, and the husband's father. And they had asked for their passports to be impounded. And in fact, the passports had been impounded. Now, unfortunately for the man's father, who was 92 years old, his passport was impounded when he was in Canada, right? So he is a 92-year-old man whose passport has been impounded. He can't now travel anywhere. His only wish was to come back to India so that he can die in peace. Right? And of course, medical costs, even in Canada, were very high. So he said, I want to come back to the country. He can't come back to the country because we've impounded his passport. Now, whether or not the power existed to impound the passport, whether it should have been impounded, it should not have been impounded, there are lots of questions there. But there is an urgency of a 92-year-old man with ill health wanting to return to the country. The High Court has the ability to cut through all of that in their writ jurisdiction and say that these facts are so compelling that in spite of adverse regulatory environment, the adverse regulatory environment that your particular matter is now currently sitting in, I will direct the union government to please issue him travel papers immediately so that he can come back. That's in the High Court, right? But that is also true in courts of first instance, whether you're looking at an arbitration, whether you're looking at a criminal trial or a civil trial. And therefore, the burden of ensuring that good facts are placed on record is on Dominus Litis, is on the person conducting examination in chief. So if you find, as the prosecutor who is opening the papers for the first time the day before the trial, that there are in fact elements of this particular witness, the facts relating to this particular witness, that have not been brought on record, you have the ability, and the court has the expansive ability, right, through section 91 CRPC and under the CPC, to bring further facts, to bring further material on record. So the reason why examination in chief or this particular process is important is that this lays the groundwork for the entire case to go on, whether it is before this court that we are dealing with, an appellate court, a revisional court, or any of the constitutional courts. All right. So now we move, and we've now got our witness in front of us. Witness has been given oath. A common difference between examination in chief and cross-examination that we're all taught and we all know is that you can't ask leading questions in examination in chief, whereas in cross-examination you can ask leading questions. If you were to ask any defense counsel of a certain age, anyone over 10 or 15 years of practice who's done a whole bunch of cross-examinations, to lead a witness into chief, a vast majority of them will find it's really hard. It's not as easy as one would think. At times, cross-examining a witness, if you're prepared, is a lot easier than leading a witness into chief. The reason is that because leading questions are barred, right? Everyone here understands what is a leading question? A question whose answer is yes or no, right? So where I suggest the answer in the question, right? So if I ask this gentleman here, is it not correct that you're wearing a lovely white t-shirt? He has to either say yes or no, right? But if I were to ask him that, describe the clothes that you were wearing day before yesterday, that is an open question, right? And so there is this understanding of between it, especially in civil matters, right, where limited chiefs are permitted, that the idea of examining a witness is to showcase that witness and to showcase what is it that that witness is bringing to the particular record. It is not a place where the lawyer is showcasing himself or herself, and this is distinct from grandstanding, right, or playing to the galleries. That's not the phraseology here. If you want a witness to say a particular thing, then you will start closing the question, right? So if I want, again, if I may use my friend here, if I want to ask him, what was it that you were wearing day before yesterday evening, right? So I'm now narrowing the scope of where I'm directing him in a particular place. The fact that I have asked this question also begs a second question: what is it about day before yesterday evening that is so important, right? So obviously that is part of my case theory, right? So you can understand now from that question, where is it that I am trying to lead this witness or take him. Lead is probably a bad word to use in this context. But if I were to ask open questions, assuming my friend, and I have no reason to disagree, is rational and understands why he's been called, he will immediately turn to matters at hand. But when a person is sitting there in the witness box for the first time, right, you're dealing with a matter, say, that happened 5 years ago. This person has been summoned, he's sitting in court. You know you can't lead the witness. How do you start how do you start your examination in chief? Right? So you'll start by, can you state your name? Can you state where you are? And barring those introductory questions. So there the Evidence Act gives you a helping hand, right? So if you, once again, open your Evidence Act, you'll find, and if any of you found the answer before me, feel free to pop up. If you look at the second part of section 142, it follows from 141. So 141 deals with what is a leading question. Any question suggesting the answer which the person putting it wishes or expects to receive is called a leading question. 142 says when they must not be asked. Leading questions must not, if objected to by the adverse party, be asked in an examination in chief or in a re-examination except with the permission of the court. Corollary to that is you can ask them in cross-examination. And then the court shall permit leading questions as to matters which are introductory or undisputed, or which have, in its opinion, been already sufficiently proved, right? So instead of going through a person's life for 52 years before you arrive at the exact date on which you are dealing with that particular witness's recollection, you can straight away come to that day. And for that purpose, if it is introductory in nature, you can lead that particular witness, right? The manner in which you would do so, and to be fair, these are concepts that are better workshopped with all of you. In a large group, it may not be possible. But if you were to make this an exercise, I mean, I'm sure you have lives, but in case you don't, if you want to do this exercise, you can, with a friend, just try and ask someone simple questions with respect to their background, right? Where they are from, where did they study, whether they have siblings. So if you're looking at that general background, how do you formulate those questions? You can do this as a mental exercise in case you don't have friends. I would have probably had to do that, right? And the idea is not so much as to the manner in which you're asking those questions. It is anticipating answers, right? What kind of answer will I get if I ask a question one way versus another, right? All right. So you'll find younger or less experienced practitioners will be eager both in examination in chief and in cross-examination to get the witness to agree to a conclusion, right? A conclusion is that, say you're cross-examining or you're examining an eyewitness to a case, to a murder. My objective as the prosecutor would be to show that this is a person who is otherwise independent, who was either a chance witness who was there because he or she just happened to be there, or was a witness who was part of a group, so is an interested party but was there nonetheless, is still independent, has reasonably good eyesight, right? You don't want at the end of the whole thing to find out that he is 90% blind. So he has reasonably good eyesight, you have all this, it was daytime, the place was well lit, and the person then describes describes whatever has happened and moves away from the stand waiting to be cross-examined. Now let's assume for a moment that the case theory of the cross-examiner is that this eyewitness was too far away to have discerned the identity of an accused. Say he feels that based on the site plans, based on the kinds of the layout of the place and the statements of other persons, he was near the car, she was near the parking lot. My friend, the cross-examiner, estimates that it is 200 meters away. So the case theory is that this eyewitness could not have in fact seen this individual. Depending on how nuanced this cross-examiner is, you will want to create a body of questions, first ensuring that the witness agrees with your positioning of that witness on that particular day, right? So if the witness says that, well, it's correct that the incident took place near the Starbucks, I was near the parking lot. Yes, the parking lot is quite large. I do recall there was a large hoarding at the corner of the parking lot. I was next to the hoarding, not the movie hoarding, but in fact the advertising hoarding. And so you're pushing the person, you are establishing where that particular person is. At which point of time, depending on the courage of that particular cross-examiner, he may end with a suggestion that, look, you were too far to actually see what happened. And a less successful approach to this witness would be to start by saying that, look, you were too far away to see anything. In which case, the witness immediately also appreciates what is going to be the line of questioning and will start fighting back, right? Will say, no, in fact, I was very close. I could see everything, right? At which point of time, you've dug your client a few feet deeper as a cross-examiner. The same issue arises in examinations in chief. The purpose is, again, as we dealt with in the first few slides, is to place facts on record, to place relevant facts, not to place arguments. We don't need the law. We don't need how these particular elements stitch together. That is the purpose of argument. There is a special stage for that, final arguments, where all this will be stitched together, where the court will determine whether or not side A or side B has won. So when you are asking questions, you have to be very careful that the questions that you are asking are directed questions. You are asking them for a particular purpose. They have to be forensic. They have to be very direct. But they should not be argumentative or not be an argument, right? And, well, conclusions. This is conclusions with respect to a witness concluding certain things, right? So if you get a witness to come and say that, yes, this document was, in my opinion, this document was forged. Who are you? Well, I'm the janitor, right? Nobody cares, right? Nobody cares what you think. All we were asking you was the office open that day, yes or no, right? That's the limited purpose that you've been called for. If you have an answer for that, great. If you don't, your opinion, frankly, doesn't matter, right? So this is what happens if you start asking conclusions or you start directing the witness towards conclusions. As a lawyer for any of the sides, you have no idea what a particular witness is going to say. Whether a witness is actually going to say what the witness is supposed to say on that particular day. Witnesses are terrible animals, right? They can agree with you, they can disagree with you. They don't know whether they are being examined in chief. Some people in black coats just yelling at them. Something is being recorded in a court, right? So these are not perfect conditions in which you will be operating. So if you understand the reason why you are asking that person questions, you are then in authority. You have control over the witness. If you have control over the witness, facts will come on board. If facts will come on board, you have a greater chance of success. And if you do it the other way around, you will in fact have an unpleasant time. Right. So for those who can't read, this is who can't read this. I'm sure all of you can read. Right? So he's big, all right, but he's definitely a wolf. And he's definitely a wolf, but it'll be up to a jury to decide whether or not he's bad, right? So whether he's a bad wolf, I mean, it's for the jury in their case. In our case, it's for the court to decide. So you don't want witnesses telling you beyond a point, even as the prosecutors, how bad a person was or how bad a particular fact is. You want the fact, and you will determine in your prosecutorial or your ability as the lawyer for the plaintiff as to the relative weight of that particular fact. Right. All right. Now, these are fairly self-evident things, but they're very hard to do in practice, right? So if you do the workshop that at any point of time in any of your trial advocacy courses, using plain words and simple language is actually very difficult to do. The reason it's difficult in many of the trials that we are currently doing is that at times we don't understand our own cases. The cases are very, very complex, right? So when we are younger, we sit at night, we prepare these long lists of questions. I'm sure all of you have done internships with lawyers. You worked during cross-examination briefs, and bunches of lawyers have been dictating questions, and you end up with 450 questions for one witness. And you power through those questions. And this often happens in arbitrations, where regardless of the answer, you're moving on to your next question. And these are long questions. A lot of these witnesses at times are technical witnesses, so you have to ask them questions about, how a coal plant works, how a nuclear plant works, how the Commonwealth Games took place, how events in that took place. In the Delhi liquor matter, although the trial has not started, you have questions with respect to how the liquor industry works, right? These are all, they're fascinating questions. But if I'm asking an area expert a question, I have to be, as the lawyer, be very careful as to what answer I'm going to elicit. Because I have read, like most of you have done your exam preps, I know only enough to pass, right? I do not know anything beyond the subject. So if this witness, especially in hard crime cases, this happens with the doctor, right? So most doctors are kind to lawyers, but the moment the doctor wants to, pay back in kind for having been called at 2 o'clock in the summer, the doctor can just go crazy, right? And say that, well, his trachea he could have been hurt on his trachea with a straw, right? And you have no way. The court is going to say, well, that's the doctor's advice, right? That's the doctor's opinion. So if you lose control of the witness, and you will almost always lose control of the witness if you are asking long-winded questions which require further corrections, and you're explaining the question to the court, you're fighting with the prosecutor, your junior is screaming in your ear, all sorts of crazy things are happening, and you end up with a 450-word question. That question is going to damage you. It is impossible for that question to help you, whether you are a prosecutor or whether you are, in fact, a cross-examiner. So, thumb rules. If you have 3 facts to ask them in 3 questions, right? Ask small questions, take the time, get your facts in order, and you'll listen to your witness. At times, as lawyers, we have our own agendas in courts. We need to get our work done. The actual answer that the witness is giving becomes secondary. Because once I've asked my question, I'm now looking down at my list now, what's the next question? And someone else is recording what that witness has to say. But if you listen to your witness carefully, he or she may actually negate your next question, or you may actually have to ask a different question. And in the context of doing trials in and around Delhi, you must be spatially aware. There was a strike yesterday in Ghaziabad, and my junior almost got beaten up, right? So, all right. So this is what you can't do. We've gone over much of this. No leading questions, no hearsay evidence. So hearsay, we are all roughly aware what hearsay evidence is. The exception, of course, is opinion-based evidence. If I'm asking a forensic expert to come in, I want his or her opinion. But again, if I'm asking a police officer who has conducted a search, I don't want that police officer's opinion on what the offender may or may not have been doing prior to the search, if that police officer was not there. Section 151, 152, the fairly self-evident, don't annoy the witness, and that surprisingly applies even in examination in chief. Don't do this to your own witness, right? So the next section is on loopholes, right? And the reason I'm pointing to loopholes is what happens if on the day of the examination in chief you suddenly realize that a horrible error has been made. The evidence that is being brought by a particular witness is dependent on the evidence that was to be brought by another witness, but you have made an error in the sequence of witnesses. You have, by way of an example, you have called for the ballistics expert without actually proving the ballistics report, right? So this is an expert who doesn't prove the report, but who's done a part of, say, the ballistics examination. Now, how do you ensure that this day is not wasted, right? The court, the answer is that you go back to the court. The admissibility of evidence is determined by the court. The court will decide on the day, and these decisions are, of course, subject to challenge, but in the context of that particular court, the judge will decide what is admissible and what is not. And Section 136 of the Evidence Act is the means through which this is actuated. And 136 is a very peculiar provision because it also permits, in language that you have to read twice to understand, that if two witnesses are in fact required to produce material sequentially, on the undertaking of a lawyer or undertaking of a counsel, it can reverse the sequence, provided that you say that, yes, I will also produce witness number one shortly, right? So these are tools that prosecutors or plaintiffs can use in the course of their examination in chief. We had two basic provisions on this. The power of the court to ask witnesses. So where this exists, whether a court is witness is being examined in chief or being cross-examined, the judge has an overriding power to ask any witness any question at any point of time. The judge can also determine the order of the witness. So in several cases, suppose there is an incident of which there are 4 eyewitnesses. If I examine one eyewitness today and that eyewitness is cross-examined, I have the notional ability to ensure that the second eyewitness covers whatever errors have been made by the first eyewitness, right? So on day 2, my eyewitness will cover the lacunae of the first witness, and so on and so forth. So the court, in terms of 231, 242, depending on which kind of trial it is, the court has the power to tell a particular prosecutor, this is of course in the context of a criminal trial, that you will examine in chief all of them first, and then they'll be cross-examined at one go, right? So although the prosecutor is dominus litis, and the plaintiff's lawyer is dominus litis, the court will also have an overriding power in determining the order of witnesses, right? Right, so now I assure you we are coming to the end. And this is about as hostile a witness can get. The caption reads, these are all children. The witness will confine his knock-knock answers to who's there, right? So sometimes you want a witness to just say what the witness is supposed to say, right? And you really want a judge to say this, that all this guy is asking you is what color is your t-shirt, right? Nobody wants to know how many TikTok videos you have, or which college you go to, how many motorbikes you have. Not one person is interested. I mean, I'm sure there are many people who are interested, but not in this trial, right? So just confine your answers to this. Have any of you seen My Cousin Vinny as a movie? No? How many of you have done CRPC? None of you have seen My Cousin Vinny. You must see that movie, right? That movie was part of our required viewing when we were in college. There was a special screening of that movie. Well, our professor said that this is actually far easier if you just watch this movie, right? It's just easier for me to then explain parts of the CRPC by just referring to the movie the next day, right? So there's a scene in that particular movie on hostile witnesses which will be lost on all of you. It was a great joke though, for the record, right? Now, you've all heard what is a hostile witness, right? This is a creature that comes to court and then deposes against the party that has called that witness, right? So I have an eyewitness who has seen someone getting murdered in a parking lot, who then comes to court and says, I didn't see anything. It was too dark. I'm blind. I was not there. I'm not even this person, right? So now there are two ways this can go. This could be a person who is telling the truth now, or this could be a person who was telling the truth earlier. We have a principle which is there at the end, falsus in uno, falsus in omnibus. And like all Latin maxims, we don't follow it, right? It means if you're false in one, you're false in all. So our Supreme Court has said that this particular maxim, this will come in almost every case, only to be noticed and discarded. Right? I don't know what enmity we have with this particular. If we don't follow it, I don't know why we keep relying on it, but you'll find it in 2023 judgments of the Supreme Court. We don't follow this. And from 1960 onwards, we've not been following this. We say that merely because a witness has made an incorrect statement does not mean the rest of her testimony is also to be discarded, right? So that's generally the gist of it. So we are in a position, so this is what really means when we say, this is what is meant by when we say we are in a common law country. Great power is given to trial courts in the weighing of the evidence that is collected, the weightage of that evidence. So we will use terms of, we are able to separate the grain and the chaff, right? So the chaff being the lie, grain being the truth. So with that ability, the mere fact that a witness has come to court and has now said that whatever you, Mr. Prosecutor, are saying, I do not agree with. This is not what I have said in my 161 statement during the course of my investigation. That by itself is not fatal either to the case of the prosecution, because there may be other witnesses. It is not even fatal to the case of the prosecution vis-a-vis that particular witness. Because 154 of the Evidence Act says that you can cross-examine this witness. You as in, you the person who has brought this witness. So I will initiate a process by declaring the witness hostile. I'll say that, look, this witness is now changing his stand from what he has told us during the course of investigation. I request permission to cross-examine. The court will consider and will most likely grant that permission. And then I get to lead that witness to his previous recorded statement in terms of 161. So section 154 of the Evidence Act, you'll read with section 161. Those of you who've done your CRPC courses recently, it is a great opportunity to revisit Tehsildar Singh, that enjoyable judgment on what is and what isn't a 161 statement. And so this is an example of how a court would deal with the evidence of a hostile witness. The evidence of a prosecution witness cannot be rejected in toto merely because the prosecution chose to treat him as hostile and cross-examined him. The evidence of such witnesses cannot be treated as effaced or washed off the record altogether, but the same can be accepted to the extent their version is found to be dependable on a careful scrutiny thereof, right? So, again, this means that the court says, depending on the quality of the other facts that you have, we will then read the testimony of that hostile witness in the context of those facts. So if there's other material to suggest that what this witness is saying is in fact incorrect, we'll go by that. It is possible that a witness is hostile only on a particular fact and not on others, right? And that's where we end. And that's yeah. Yes, please.
Thank you so much, sir,
Yeah.
for such a wonderful conversation. People who have questions can ask right now. Anything? I have one question,
Yes.
if I may.
Sure.
So, first of all, thank you so much. Secondly, I wanted to know your experience with respect to examination in chief. Like, how has your experience been over your law journey?
See, most of the matters that I've done are as a defense counsel, and to be honest, in matters where the examination in chief is going to take very long, we mostly are not present for the examination in chief, right? So we'll mostly leave a junior behind. देख लेना क्या हो रहा है वहाँ पे मैं कुछ और करके आता हूँ, right? That's normally what we do. But as we are growing in experience within the profession, we are finding that being present during examination in chief is actually very useful if you can actually do it. The tragedy of our particular way of doing trials is that, and it's more a criticism of us than of anyone else, we're not able to give the kind of time and space that is required to do one of these trials. So if you were to compare, and I'm sure a lot of you have already done so, and in the future in the near future will do so, if you were to compare how we do our trials versus we in India or even in Delhi do our trials compared to trials that are done in any other part of the world, whether it is in Europe, whether it is in Australia, it is in the UK, or the US, or in any of the other continental countries, you'll find that the amount of time that is dedicated to each trial is far in excess of the kind of time that we are able to dedicate to our trials over here. The number of trials that we do are ridiculous in a year, in a day, right? The number of trials I'm expected to attend can be 4 or 5 trials in a day, where each day something small is happening. And because we have this very differentiated way of doing trials, like we don't just start on one day and end a month from now, right? I'm sure many of you followed the Johnny Depp and Amber Heard trial, right? In that particular, you're seeing that is a trial that is going on a day-to-day basis. You are able to, because it was being live streamed, as a lot of us as trial lawyers here were looking at the manner in which they were doing their cross-examinations. It's interesting because a lot of the principles are the same. If you go back and listen to any of the examination in chief, you'll find a lot of these principles are being followed by those counsels. But they have a system where they're going to do that particular trial in the 3 or 4 weeks that they did it, and then they end up in a result. For various structural reasons, we don't do our trials like that, as a result of which our trials get stretched over time. But my experience in examination in chief is that if counsels, if as a defense counsel you're paying attention, there is a tremendous amount that can be achieved by just paying attention to what the prosecutor is doing, what the prosecutor is bringing on the record, what the prosecutor is keeping off the record. because we will do our own assessments the day prior, right? That this is what we think is going to come on record. We'll suddenly find that half a dozen documents are not coming on record. So if you are ready with your case theory on the opposite side, examination in chief is a great way to prepare for your own cross-examination, right? Your cross-examination gets limited. So my experience otherwise is generally neutral. It's not a particularly exciting event, but yeah.
Thank you.
Yeah.
Anyone else? Yeah.
Firstly, thank you so much for the lecture. It was pretty insightful. I had one question.
Sure.
We know the state of under trials in India, right, and how many of them there are. So we learned while we were discussing in class that by the time the whole case comes to the stage of trial, right, it has been years. So in that case, obviously the defense obviously gains an advantage because the witnesses are not really clear on the facts of the case because it has been so long since the whole situation happened. So in those circumstances, what are some things that the examination in chief, what are some things the prosecution can keep in mind to make sure that the witness testimony is still important and not just disregarded due to the paucity of time?
So that's a great question, right? There's one matter, in fact, that we are arguing in the Supreme Court where I'm appearing for a defendant, for an accused. The offense took place in 1981, right? The conviction was in 1984. The High Court of the concerned state took 33 years to decide the appeal in 2017, and now we are arguing whether or not that person should spend life imprisonment or not. And that, so you're absolutely right. So there, of course, the trial took place in 3 years within the incident. There are other trials that have taken place, far removed from the incident. That is really where the Evidence Act itself provides, in terms of section 33 or 34, what kinds of statements of persons who have deceased can be used, where can you use secondary evidence where primary evidence is not available, and you as a prosecutor then you have to be a little more creative, right, with respect to your own case. You have the ability to add new witnesses. You have the ability to call for fresh records. The advantage that is there, that you would imagine is there to the defense, is not so in every case. Because although theoretically as a defense counsel on behalf of my client, I have the ability to call for defense evidence, but the vast majority of cases are decided on the basis of prosecution evidence and the cross-examination that is done there. So if those witnesses are not available to me as a defense counsel, I am equally at a disadvantage. If I have a mandate, if I have a case theory that I have to prove, whether it is to a preponderance of probability, is not to beyond reasonable doubt, but if I want to assert a fact and that person is in fact deceased, then I have nowhere to project that fact. I can't project that fact onto the trial court record. He's not there for me to project it through him. So it cuts both ways, but you're absolutely right. It cuts, it prejudices the prosecution far more than it would prejudice the accused.
Hello, sir.
Hi.
Thanks a lot for the session. I have one question. When we are conducting examination in chief and we are presenting the witnesses, to what extent does the counsel or the lawyer speak to the witness beforehand? Is there any tutoring that takes place, or is the witness completely alien to the lawyer beforehand?
Again, that's a great question. There are two parts to that question. If, again, I'll bring you in for, say it is a civil matter. In a civil matter, the plaintiff's witnesses, presumably, most of them, are aware of the plaintiff's case, right? So, to the extent that they are aware of the case, I would assume that they are aware of elements of their case. Say in a civil matter, I also want to call for bank records, right? So that particular bank employee that comes may be alien to the facts of the case itself, but that examination in chief is limited to only the record that that person is bringing. You will all go through your ethics course sooner or later. In the course of that, you'll find that you are not supposed to be tutoring witnesses. So, if you're asking me whether it happens, I'm sure it does. But it's not meant to happen. It's certainly not meant to happen on the criminal side, where, again, I mean, roughly 60% of the witnesses who will come would have statements recorded under 161 CRPC who have been interacted with by the prosecution or by elements of the prosecution, the investigating officers, etc. So they have all interacted with the investigation. Whether they have interacted with that particular witness, with that particular prosecutor, probably not. But practically, when I go to a court, say at 9:30 in the morning, the court is going to sit at 10, I will find the prosecutor talking to the witness in the morning. But that is not something that I would object to, because I want the prosecutor to know what he or she is doing. And if I am ready with my cross, I am reasonably certain that regardless of how, because I have prepared myself against the standard of the charge sheet, which is the best case that they can come up with. Right? So if the witness is going to come and say that I saw him at a distance of 30 feet, it will be there in the charge sheet somewhere. So I'm ready for that. So whether you're reminding him, it's just make things faster. So I don't care, right? That they can, and to some extent, it's a reasonable process. The prosecutor wants to know who are you, what have you come for. So those kinds of interviews are I think par for the course. But at the same time, if that witness now comes and says, well, I saw him not from 30 feet, but from 5 feet, I have an advantage as the defense counsel because that is beyond the record now. So, and that's fairly elementary. So that's not what normally happens in a prosecution. So those, between the prosecutor and the witness, the discussion is usually logistical in nature, that these are the documents, do you know this document, can you help me find this document? So that kind of, those kinds of interactions are not something that are really objectionable, right? But I'm sure tutoring does happen, but it's not meant to happen.
Hey,
Hi.
thank you for the talk, sir.
Thank you.
I think we are all law students and potential litigators of the future.
Brilliant.
What advice do you have for us to maybe train ourselves during a law school or in the legal school? Or maybe, if I have to rephrase in another way, what sort of lawyer would you look for if he has to or she has to work under you?
If he has to work as a litigator?
Yeah, as a litigator. What type of things you would look for in a good litigator?
Look, the threshold of competence, let me say, that is exhibited by almost, I mean, without exception, to students that have graduated from your college or your peers, right? Doesn't really matter in what order they graduate in, is normally so high that you breach all requirements of competence from day one, right? This is a question, this is a fact, and it's relevant, right? Because the vast majority of the support that a court gets today is not of the same standard, that these are not people who have had the same opportunities that you have had, right? Over 5 years to or 3 years, depending on which course you've done, in an institution like this, you have been exposed to a lot more than previous generations have been exposed to. So your competence levels are already quite high, respective and of course adjusted for your relative ages. The fact that you have graduated from institutions like this means that your basic skills, your soft skills are really good, right? Very, very rarely will you find someone with poor soft skills who come out of institutes like that. So what I would be looking for are people who are willing to learn on the job, right? Because no matter how many of these seminars you attend, it's very different when you are actually inside a court, and I'm sure all of you experience that in your various internships. And whether it's a court, whether it's a law firm, whether it's an international body, the ministry, wherever you're doing your internships, in a newspaper, in a company, when you actually interact with how so for example, I have to look up which is the provision for examination in chief for this talk. I have no idea what the provision is. I know it's there somewhere, right? So I know it's there. I have to look for it. I have to identify it, to make the slide. So I found it there, right? So the knowledge that is required is not so much the provision number. What is it exact? What does it say? How many judgments are there on point, right? And especially in the environment that you're growing up in, where all this information is available to you in your phones, in your laptops, etc. So the kind of student that is that was required 30 years ago or 20 years ago. Let me talk about 20 years ago. Is very different from the kind of student that is coming out today. So you all have a lot of information, you have access to a lot of information. So the focus is now on what you do with that information. It's because not only you, but your peers, your near peers, you are competing with not just the batch that you're graduating with or the batch across the country that you're graduating with that particular year. You're competing with people who've been around for a year more, for 2 years more, right? So you're roughly competing for 3 years, say. So how do you distinguish yourself in that? You can't say that I speak very well. All of you speak very well. You can't say that I've gone to a good college. Most of you have gone to a good college. So then you're looking at distinguishing features. I would look at people who are willing to learn, and it's really difficult. It's not. It sounds glib, but it's not, because I find interns who come from across the country unwilling to say that I don't know the answer to this. Right? If I ask them a question, I'll get 6 minutes of perfectly curated English without the answer. Right? And it's a work of art. It's improving each year. I get better and better. It's footnoted. It'll come with little dance emojis. I mean, I'll get the full treatment of full beans, except the answer. I don't expect the answer. I don't have the answer most of the time. I mean, I have to appear in court tomorrow. I don't have the first clue of what I'm going to say tomorrow, right? But it'll all start with when I'm driving on the way back, this lovely ride that I have back to Delhi. When I'm on the phone with my juniors, I'm going to have to ask them, what is it that I'm supposed to say? It'll be, I mean, I would seem like a god if I were to tell them, I don't even need your help. I know exactly what I'm going to say, right? But I know that that's not true. So that being able to be self-aware, right? That you are entering an environment that is just possible, that you're not fully ready to be in that environment. It's not that you're not capable of being ready, but you're not there yet. The moment you're willing to make that adjustment, across the board you will be accepted. It doesn't matter. It's not just for litigation. I have counterparts in law firms who are looking for the same thing. They will teach you what they need from you, and you have the ability to deliver to them what they want. But that communication has to happen in a manner that is pleasant for both sides, right?
Hello. Very good evening, sir, and thank you so much for such an insightful session, first of all. My question is related to what advice would you give to first-generation lawyers who wants to be potential litigants in the future, considering that the litigation is a very competitive field? So, yeah.
Well, a lot depends on where you want to litigate. I'm a first-generation lawyer, right? So if you want to litigate you have to choose your city. You have to play on whatever advantages you have, right? There are advantages. You're standing, if you're looking at a hierarchy of just say first-generation lawyers, you have advantages over the vast majority of people who are going to graduate with you, right? Just by virtue of the fact that you have studied in a fairly eminent institution. That by itself gives you an advantage over, I'd say, 90% of the people who are graduating with you. So I would not really look at it as a disadvantage being a first-generation lawyer. There are many advantages of being a second generation or a third generation lawyer, but there are equally problems with being a first generation or second generation or third. They have their own set of issues that they have to deal with. First generation lawyers have disadvantages insofar as their parents or their grandparents or their uncles and aunts aren't in litigation. But you have no fixed abode. You can go and start from anywhere. It really doesn't matter, right? You don't have to start doing service matters or tax matters because that's what you've been doing for the last 700 years. So you can do pretty much what you feel like. But you have to rely on the advantages that you have. So for example, I encourage a lot of students who have this question to consider practicing in the towns that they are from or the cities that they are from. As long as practice is viable of a standard that is acceptable to you, those are excellent choices to make. And the ability to distinguish yourself in a smaller jurisdiction as a first generation lawyer is often higher, right? So there are advantages, disadvantages in depending on where you'd like to start practice. But that my advice to you would be, consider that question first. Where would you like to practice? And then you can move on from there.
Again,
Yeah.
thank you very much, sir.
All right.
Sir, I had one question.
You have a question.
Uh, so, sir, more often than not, we see even in movies, courtroom dramas, and also in the real courtrooms that the opposite lawyer is often going to object and going to stand up and going to say that objection, my lord, and to a particular question that is there in an examination in chief. I happened to witness once that one lawyer said that this is a hearsay while the other lawyer was doing the chief examination. The other counsel said that this is a matter of argument. So, sir, in such cases, should your job as the opposite lawyer, who's standing on the other side, should be such that to postpone that question for the matter of arguments, or should you be objecting there and there?
All right, great. So if during the course of examination in chief, that I am examination in chief is going on, as a defense lawyer I object. If my objection is sustained immediately, then the prosecutor has to reframe the question or avoid the question altogether. If the prosecution pushes back and says that, look, this is a question of admissibility, we'll decide it at a later stage. Normally, no prosecutor will say that. Normally, the prosecutor will say that your objection is garbage, please decide it right now, right? And more often than not, we'll lose. So it is normally the defense who is saying that just leave my objection be and decide at the final stage. So that is a considered retreat where you're telling your client as well that, look, the objection is recorded. So what you would do is in the narration of the evidence, there will be a bracketed portion where it will say counsel for the defense is objected to this particular line on the ground of mode of proof, on the ground of admissibility, whichever is the test, and this is something that will be examined at the final stage, and that will be left then for someone to collate at the end, and you have to now agitate those issues. But there is now increasingly a view being taken by high courts, and I think there is a Supreme Court view on this, that objections have to be decided immediately. So the court will stop the matter, either decide the objection immediately there, or will decide it, say, the next day, keep it as an application, depending on the nature of the application, right? Whether if it is an oral objection, it will be decided then and there. If it's an application that requires some more effort to be put in, or an objection that requires some more effort, court may call for an application and decide it as a miscellaneous application during the course of the day or the next day. Right? We done? Are they free? They're not. All right, thank you.
So, on behalf of the Trial Advocacy Society and I think the entire student body, I would like to extend my gratitude to Mr. Shri Singh for coming here and enlightening us on such a crucial aspect of the trial process, that is examination in chief. And I think Sir did not do justice when he said that examination, like a session on cross examination, would be much more interesting, because the way he conducted this session, I found it to be so very interesting. And I would also like to extend my gratitude to Professor Aparna Babu George and all the faculty that is connected with the Trial Advocacy Society. I would also like to thank the photographer and the videographer for beautifully capturing this event. And finally, I would like to thank all of our attendees who graced this event and took in all the knowledge that Sir had to give to us. And I wish you all a very good evening, and thank you so much. Can the members of the Trial Advocacy Society just stay back for a quick picture?